First of all, I'd like to say thank you for all coming today. It's also a pleasure to see so many people I've worked with in the past on some very difficult cases. What I intend to do today is to really provide an overview and condense the law in this very complex area. There are notes, I understand, that have been put about, which should be before you. But what I'm going to talk about really is to gift maintenance wills in relation to protected parties, and provide an overview of the law in relation to that. And then I'm going to talk specifically about settlements, gifts and statutory wills. And then I'm going to talk about maintenance generally. And then I'm going to go through some case law since Repeat, our famous case of Repeat in 2009, and go through to some cases up until quite recently. So if I start with an overview, a lot of this has been covered in some ways today, but I'm going to bring it all together. The Mental Capacity Act 2005 obviously came into force in 2007, and essentially Section 1 provides the 5 key principles which are contained in paragraph 5 of my note. You will have heard of these key principles. I'll go through them. A person must be assumed to have capacity unless it is established that he lacks capacity. A person is not to be treated as unable to make a decision unless all practical steps to help him to do so have been taken without success. A person is not to be treated as unable to make a decision merely because he makes an unwise decision, and an act done or decision made must be done or made in his best interests. And finally, before the act is done or the decision is made, regard must be had to whether the purpose for which it is needed can be as effectively achieved in a way that is less restrictive of the person's rights or freedoms. Those 5 key principles are, everybody will know, very onerous to actually comply with. The key point is what the legal authorities say, which we talked about earlier on today, is that the key principle is the best interests, ultimately and overall. Everything was coming down to that. Section 2 of the Mental Capacity Act tries to define lack of capacity. I use the word tries, whilst it is a statutory definition, it's not always as straightforward towards apply that statutory definition. And my view is it's not all encompassing. The question, it's a balance of probabilities approach, so it is the civil test that is often applied, which is essentially, is it 50% or more, the position that it can be said that there is lack of capacity. Section 3 of the Act defines situations where a person is unable to make decisions, and this defines circumstances where a person is not deemed to be unable to make a decision when not able to understand information presented, but could do if communicating using other methods. So the point there is that when a person appears to lack capacity, you've got to think about other methods in order to assess whether or not they do actually lack capacity, and that's quite a complex task. So for example, you may use other communication methods, or may need to look at introducing an expert in order to use those communication methods to get to the point of whether or not there is capacity or not. The Act also provides for short retention spans. So in those circumstances, even when in other situations there may be a lack of capacity, there may be capacity in short retention spans. So again, very complex stuff, because how do you assess when they've got a short retention span? It's quite difficult. Now, it's absolutely essential to, and what all the authorities say is that when you act as a deputy or an attorney it's absolutely essential to use the Section 4 checklist. And this is provided for the approach in Read P. The Code of Practice also provides essential guidance and support. The point of the Code of Practice is it is actually statutory, and it must be looked at by professional deputies. Essentially, there are certain categories of persons who have a legal duty to comply with the code, and if you do depart from the code, then there has to be a very good reason for that. So you should be recording that as a very good file note. The categories are attorneys, deputies, advocates, anyone acting in a professional capacity, or anyone who is paid to act. Then we have the Court of Protection Rules 2007, which is consistent with civil procedure rules. The default position is if it's not covered in the Court of Protection Rules, then the default position is the civil procedure rules. Permission is not always necessary to apply to the court in relation to actions, in relation to certain actions. Only if the application relates to property and affairs, appointment and removal of trustees, application for wills, statutory wills, gifts, personal welfare, it's not necessarily a requirement. Then at page 3 of my notes, I have the powers of the Court of Protection. You can see there at paragraph 26, the Court of Protection powers comprise deciding whether a person has capacity to make a particular decision, making declarations, decisions or orders on financial welfare matters affecting people who lack capacity to make such decisions, appointing deputies to make decisions for people who lack capacity, deciding whether the last and enduring power of attorney is valid, removing deputies or attorneys who fail to carry out their duties. And that essentially is the powers. In summary then, in relation to my overview, I would say that the practical approach to take is that there must be an assumption, the starting point is there must be an assumption of capacity in all cases, unless we're able to show otherwise, and a balance of probabilities. And expert evidence is clearly obviously going to be critical. I also say as well, certain professionals can make decisions, as we know, in relation to personal care without the requirement of an application under Section 5 of the Act. But obviously caution does need to be applied in that regard. Also Section 5 provides for resolutions in relation to disputes outside of the Court of Protection, which often can save a lot of money, but again caution does need to be applied, because obviously it must be at all times in P's best interests. I turn now to settlements, gifts and statutory wills. The Section 18H of the Mental Capacity Act 2005 provides the powers to the Court of Protection to direct settlements of gifts and directions in relation to settlements and gifts. Often if it is the case that there's trust involved, unanimous decision of trustees not usually interfered by the court. However, you still must apply to the Court of Protection. All gifts and settlements and statutory wills must be in P's best interests, and guidance of this is provided by the Public Guardian practice notes, which are very detailed. The key point here is that there must never be a generalised approach. Each case must be on its own facts and take into account of all the relevant circumstances. Whilst you can compare to other cases, the point is that it's each on their own facts, and you simply can't take a general rule to any case. The meaning of a gift is defined by the Public Guardian practice notes as well. In relation to deputies, the order of appointment of a deputy is key. The content of the order always should be looked at very carefully, and this provides for the deputy's powers. Usually, those powers are very limited in relation to gifts. And usually you're likely to have to make an application to the court protection. In relation to an EPA attorney, the Mental Capacity Act allows for powers to grant gifts in certain circumstances, which you see at paragraph 43 of my notes. I just turn to that. So the Mental Capacity Act says that an EPA attorney may make gifts of a seasonal nature on anniversary of birth, marriage and civil partnership. These seasonal or anniversary gifts may be made to persons, including an attorney, who are related to or connected to P. Make gifts to any charity to whom P made or might have been expected to make gifts. The value of each gift should not be unreasonable, having regard to all the circumstances, and in particular the size of P's estate. An attorney is not obliged to make any gifts. The attorney is obliged to follow any restrictions or conditions in the EPA about gifts. And the restrictions on gifts also apply to unregistered EPAs, provided P still has capacity to make decisions and has agreed to the EPA being used by the attorney. In relation to attorneys, therefore, the paragraph 45 of my notes essentially say that the value of a gift mustn't be unreasonable. All the circumstances must be taken into consideration, and regard must be had to the size of P's estate and proportionality. Practice Direction F to Part 9 of the Code of Protection Rules provides for the procedure for making a gift. I won't go into that in detail, but it's set out clearly there. Also, needs of third persons is taken into consideration under the Mental Capacity Act, which allows for this. Most deputy orders will allow for this, but there must be a proof for a need in the past or future, or a future expectation of a need. For example, maintenance of spouses. Most deputy orders will deal with this, but if in doubt about the extent of the power, then an application should be made to the Court of Protection. The Mental Capacity Act also allows attorneys to benefit other persons if P might be expected to provide for his or her needs. The attorney may do whatever P might be expected to do. The extent of the power is in the EPA, and you should apply to the Court of Protection if in doubt about the extent of the powers. In relation to LPA attorneys, the Mental Capacity Act does not expressly permit an LPA attorney to benefit themselves or other persons by providing for their needs. The Court of Protection has confirmed that an LPA attorney may provide for family members if P is legally obliged to maintain them. An application to court is necessary if an attorney wishes to maintain anyone else. Caution must be applied. What if P expresses a wish to make a gift? P is not necessarily prevented under the Mental Capacity Act from making a gift. The assumption is that if he hasn't got capacity, he can't make a gift. But the point is that you must consider the Section 3 guidelines at page 68 of my notes, and that essentially you must take into account P's expressions of wishes. So then I turn to paragraph 68 of my note. Section 3 of the Mental Capacity Act requires P to be able to understand the information relevant to the decision, retain that information, use or weigh that information, and communicate his decision in order to have the capacity to make a decision. So that's a consideration that needs to be taken into account when he does express an opinion. Even so, even if you still lack capacity, you still have to take that into account. The important point, therefore, the requirement is that wherever possible, it must involve PE in decision making. This is a requirement of the Mental Capacity Act Code of Practice, which I point out in paragraph 70, page 6 of my notes. In relation to excessive gifts, what can you do? I've dealt with this at paragraph 72 of my notes. And this is dealt with in sections 5.21 to 5.24 of the Mental Capacity Code of Practice, which says, if the Deputy Attorney makes excessive gifts, the Public Guardian may apply to the Court of Protection for removal of the Deputy or Attorney, and if appropriate, ask the Court to arrange for a Deputy or new Deputy to be appointed. Apply to the Court of Protection for the security bond of a Deputy to be called in. Instruct the Deputy Attorney to apply for retrospective approval of the Court of Protection in circumstances where such an application would have a reasonable prospect of success. Request the Deputy Attorney to seek the return of the gifts and restitution of police assets, and refer the matter to the police or other relevant regulatory or safeguarding bodies. Quite strangely though, even if you refer to that matter, it might not actually be in the best interest to refer the matter to the police, and there is authority for that, which I'll come on to later. The other point is, a new deputy may be authorised also to take legal action to recover the money gifted. Again, you're going to need Court of Protection authority to go down that road because of the expense of doing that. So in summary then, in relation to gifts, deputies attorneys must apply to Court of Protection when they have no power to make gifts. There is no informal process involved. Formal application to the Court of Protection must be made. And the key factors are proving it is in P's best interest, proving that P's future needs can still be taken care of, and proving that endeavours have been made to involve P in the whole process. I come on to maintenance generally. It's a continuing duty of the Deputy Attorney, as you know, to continue to assess the decision-making capacity. That's quite an onerous task. But this must be evidence on your files, and you must evidence this process as an ongoing practical process that you should take in relation to every client. And you must evidence that you've never made assumptions about capacity, and you must follow the MCA and COP rules in relation to that. I'll turn to the case law. Before I go into the case law, I'm going to refer to paragraph 80 of my notes. And so it's also always worthwhile looking at the position prior to the Mental Capacity Act, because you can see whether the law really has radically changed since then. The authorities prior to the P in 2009 assumed that P was having a brief lucid interval at the time of making of a statutory will. During that lucid interval, P was assumed to have full knowledge of the past and a full realisation that as soon as the will is executed, he will relapse into the mental state that previously existed. The court considers not a hypothetical P, but an actual P, and I think that's the key point, is that the court, in the past, this wasn't an objective test. They considered actual evidence of P's conduct with all the antipathies and affections he had while at full capacity, and seeks to make a will, which he acting reasonably would have made. P is envisaged during the hypothetical lucid interval as having been advised by a competent solicitor in the normal cases. P is envisaged as taking a broad brush to the claims on his bounty, And that was the old law, which was set down in Reed DJ 1982. Then in 2009, REP changed all that and REP essentially provided guidance on how it should exercise its powers under the Mental Capacity Act. What REP said essentially is that all previous authorities are no longer relevant. So it basically ripped up the old law. The essential goal was P's best interests. This is entirely an objective test, and you must follow the structure of the MCA when making decisions. P's wishes and beliefs also must still be considered, but presumptions must not be made about P. So that there's difficulties here, trying to be objective, but also trying to consider and weigh up P's wishes and beliefs. And because of that, there's room for difficulties and error there. Then we went on to the case of ITW versus Z and N on various charities, 2009. In this case, N was a childless widow. In summary, Z was suspected of taking financial advantage of N, and Z lived with N for a lengthy period of time. An order was provided for an interim statutory will and for removal of Z from N's property. The court then listed the principles to follow when making a statutory will, and this is at paragraph 85 of my notes. Yep. And you see in paragraph 85, the starting point was the structured decision-making process prescribed with the MCA. Considering third parties' views, there was no place for reference to judicial decisions under earlier statutory regimes. The Act laid down no hierarchy as between factors which had to be borne in mind. The overarching principle was the judicial evaluation of what was in the individual's best interests. The weight to be attached to the factors would differ depending upon the individual circumstance of a particular case. A list of further matters there. I'm running out of time, which is worth looking at. But those are the key points. Coming then on to JC in 2012, paragraph 86 of my notes. This was a case that doubted the effect of the balance sheet approach. Then we had the case of Aintree and University Hospitals Trust of 2013, which said that it is the wishes and feelings of P that must be considered, not the wishes and feelings of a reasonable person in P's position. Then we have the case of NT versus FS, in which the D applied for statutory will on behalf of F. F was suffering from Alzheimer's. There were many potential beneficiaries, including charities. In this case, the court considered a document made by F for evidence of testamentary intention some 26 years prior. It was determined that such a document was not of magnetic importance because it did not meet the best needs test insofar as circumstances had material